Good afternoon. Hello, my name is Maria Fanou. I am one of the academics at the School of International Arbitration here at Queen Mary University of London. Each year, the school organizes, alongside the LLM modules, a few co-curriculars that focus on certain topical aspects of international dispute resolution and notably arbitration. The aim of these co-curriculars is to enhance the focus on arbitral practice and offer an opportunity to our students to hear different perspectives on issues that they have studied during their LLM program. In addition, such co-curriculars are another way to nurture the deep relationships that the School of Arbitration has built with the wider international arbitration community since the 1980s. We will be soon celebrating our 40 years anniversary in April 2025. The typical format of a co-curricular, and we will be following that format today, is to invite an arbitration professional, give a presentation, and have another practitioner comment on it. The discussion is moderated by an academic from the School of Arbitration and is followed by a Q&A. So prep your questions. The topic of today's seminar is arbitration in Asia, a discussion with the Secretary General of the Hong Kong International Arbitration Center, Ms. Joanne Lau, to my left. Joanne leads the Secretariat and is responsible for the overall management of the center, including overseeing its international dispute resolution services and operations across its Hong Kong, Shanghai, and Seoul offices, right? Prior to joining the Hong Kong Arbitration Center, Joanne was a partner at Allen Overy, and we're truly delighted to have you here today. And we look forward to hearing from you about the key changes introduced by the new rules, as well as recent case statistics and other trends. To comment on Joanne's presentation, we're privileged to have Nicholas Peacock with us. Nicholas Peacock is an arbitration practitioner with more than 30 years of experience advising and acting for parties, including many years as a partner of international firms that included Herbert Smith Freehills and Bird & Bird. Nick advises and acts on both commercial and investment arbitration cases across a range of industry sectors. In addition to his rich counsel work, he also sits as an arbitrator. So thank you very much both for being here today during a very busy London Disputes Week and a sunny day. Without any further ado, Joanne, the floor is yours.
Thank you. Thank you very much. And let me just start by thanking Maria for putting this together and Queen Mary University for hosting, and also Nick for taking time out of a busy week to comment on this. It's my first time to the campus, so I'm delighted to be here. And as Maria was saying just now, I know you're celebrating your 40th anniversary, and actually HKIAC was established in year 1985. So we are also celebrating our 40th anniversary next year. So I thought that was a very lovely coincidence. I know I have around 30 minutes or maybe a bit less. And how I plan to spend the time is, first of all, I'll share a bit more about our recent case statistics to give you a flavor of our caseload. And then the second part of my presentation, I will introduce our 2024 Administered Arbitration Rules. And that's very new. It just came into force 1st of June, just last week. So I want to give you an overview of what we have changed and maybe provide some additional information about the thought process that went into it. And finally, the third part, I will talk about the interim measures arrangement between mainland China and Hong Kong, because this is of interest and very helpful actually to a lot of parties with transactions or disputes with Chinese counterparties. So I do want to share a bit more on that. Right, so starting with our 2023 case statistics, even though our name, Hong Kong International Arbitration Center, we don't just do arbitration cases. So we also handle domain name dispute resolution, mediation, and the third part is adjudication. And actually adjudication for us is going to be a growing area because in the UK, I know you already have construction adjudication, whereas in Hong Kong, a bill was recently released. So we are expecting a potential wave of construction adjudication cases. So last year we had 500 new cases, 209 were domain name dispute resolution cases. Arbitration remains our main core business. So amounts those 500 cases, we had 281 arbitration cases, 184 of which were fully administered. A lot of those were under our 2018 HKIAC rules. Some of them were under the UNCITRAL rules. And to put all of that into context, I also want to share with you the trend in the past few years. Usually I am a bit hesitant about overly focusing on the difference between 1 year to the next because it can really differ depending on, say, whether there are lots of related cases, so there could be fluctuations year on year. But I would say in the past 6 years, the caseload for HKIAC has been strong and steady. 2023, there was a dip in terms of case numbers compared to 2022. But if you compare that to, say, year 2021, it's a pretty similar level of caseload. What was very interesting last year, though, is we had a record-breaking total amount in dispute. So last year, the total amount in dispute reached $12.5 billion US. So that's very significant for us. And if you look at the average amount, then I think that comes to around $60 million US per case. So a lot of the 281 cases are high value, complex disputes. And here it's a breakdown in terms of industry sector. And year 2023, I would say it's not an exception for us in terms of industry sectors. If you look at the past maybe 5 to 10 years, the top sectors are consistently these. So corporate, commercial, although if you ask me, I think there is some overlap between corporate and commercial disputes, but corporate and commercial disputes, construction, maritime, banking, and financial services, these consistently feature as top sectors which generate disputes for HKIAC. And I've been asked from time to time, like last year, that there's a significant amount in dispute. What caused that spike or what generated such high value disputes? We haven't done like an in-depth study on that yet, but I can just share some maybe informal observations. A lot of our corporate and commercial disputes, they are complex joint venture shareholder disputes. So I think those tend to be quite high value and complex. Construction dispute, we had some which are, again, very large, which contributed to it. In Hong Kong, when we talk about shareholder disputes, a lot of them are also to do with exit, like say some investors wanting to exit, determining, say the put option price, that sort of disputes we see quite regularly and again, high value cases. Here we haven't done a further breakdown, but if you talk about, say, shareholder joint venture disputes, they can be across all different types of industries. So pharmaceutical sector, consumer and retail, technology sector, those are all sectors which can give rise to HKIAC disputes. On arbitrator appointments, last year we made 172 arbitrator appointments and confirmed 112 arbitrators. Just focusing on progress made by our own institution, we actually made good progress in increasing gender diversity in our arbitral appointments. So right now, in terms of arbitrator appointments made by HKIAC in 2023, around 35% are female arbitrator appointments. But we recognize that this is still not gender parity yet, so we're making a lot of conscious efforts in trying to increase that percentage. And as I'll come to later in our 2024 rules, we've also introduced a new provision addressing diversity. On how international our cases are, 75.1% of our cases involve at least one non-Hong Kong party. And if you just look at our administered arbitrations, then that figure is even higher. So amounts are administered arbitrations. 90% of our cases involve at least one non-Hong Kong party. And in 2023, parties came from 45 different jurisdictions. These are, again, pretty consistent with previous years. So Hong Kong, mainland China consistently are top two users. BVI, Cayman, Singapore, US, Russia, South Korea, Japan, UK. Perhaps one notable observation is that Russia featured in our top 10 users for the first time in year 2023. Hong Kong has a very international history and expertise, but also specific expertise in handling a lot of disputes involving one, say, mainland Chinese party and one foreign non-Chinese party. So we are sometimes asked how many of our cases involve mainland Chinese parties. And last year, 40% of our cases involved a mainland Chinese party. And that is, again, pretty consistent with what we've been seeing in the past few years. But with 40%, there are still a lot of other cases which don't, at least not directly involve a mainland Chinese party. For language, 83% of our cases are conducted in English, 12% are in Chinese, and 5% are bilingual, so in both English and Chinese. Right, so turning to the second part of my presentation, our 2024 Administered Arbitration Rules. I should just start by saying this is not an overhaul of our 2018 arbitration rules. And in fact, the 2018 rules, I think, have been operating quite well. People have positive feedback. So this is more, I would say, a refinement of our 2018 rules. And one central theme that we kept to is that HKIAC adopts a light touch approach to case administration. So we try to leave it to parties and tribunals to decide how they want to run their arbitration. So to give you a couple of examples, so for example, we don't have like an award scrutiny process. Our counsel team would still check, and if there are obvious errors, they would raise it, but we don't do like a line-by-line checking of award, and that you could say is to prioritize efficiency to make sure awards can get released quickly. The other, I think, maybe a bit different from other institutions is that in terms of how we pay tribunals, we let the parties choose. So either ad valorem based on the value in dispute, or they can choose hourly rate, and the hourly rate is subject to a cap. And if the parties don't agree, then the default is hourly rate. So again, we want to give parties that flexibility. So for our 2024 rules, I've tried to categorize our key changes into a few key objectives. One is time and cost saving measures. I think right now we hear time and time again that parties want arbitrations to be conducted more quickly. There are feedback saying, oh, it's becoming too expensive. So as an institution, we work really hard in trying to make sure that we achieve those time and cost saving objectives. The second is to enhance and protect the efficiency and integrity of proceedings. And I'll come to that a bit later on what I mean by that. And three, the 2024 rules aim to respond to developments in international arbitration, and maybe not just confined to international arbitration, but how the world is developing generally. So turning first to time and cost saving measures, one change that we introduced or one additional provision that we added is to clarify that tribunals have a range of case management powers to conduct an arbitration efficiently. So that's in 13.6 of our rules. And we listed quite a few examples in there. For example, determining preliminary issues, bifurcating proceedings, conducting arbitration in sequential stages, etc. And these are actually not new because tribunals, you always already have those case management powers, but we wanted to make sure that tribunals do remember that, and to expressly say it in the rules, I think can help encourage tribunals to be braver in adopting these case management powers. And one additional point is that in our previous rules and in our 2024 rules too, we already had a provision on early determination procedure. So if it's a point of law manifestly without merit, then there's an early determination procedure. But we wanted to avoid like any like potential situation where a tribunal thinks I can either do early determination or nothing at all. So by adding this provision, we make it really clear that in addition to early determination procedure, a tribunal you still has all these other case management mechanisms which you can put to good use. The second point here is closure of proceedings. So in our previous editions of our rules, we already fixed the time limit saying an award should be issued within 3 months of closure of proceedings. But what has sometimes happened is that the tribunal may take a long while without closing the proceedings. And if that's the case, then it means the timing of when the award would be released would also be delayed. So that's why we've now added a time limit on closure of proceedings as well, to say at the end of all the substantive written or oral submissions, then within 45 days, the tribunal should be closing proceedings. So again, that's to enhance the efficiency to achieve time savings. The second point on protecting efficiency and integrity of arbitration, we've introduced some provisions to give HKIAC as an institution a bit more power to ensure oversight of efficiency and integrity. So for example, when we confirm designated arbitrators, we can take that into account. And 13.10, if there are serious issues in exceptional circumstances, we may revoke appointments. And I've put exceptional circumstances in bold, which really is to emphasize that this should be exercised only in very rare situations. Generally speaking, I think arbitrations are run well. Arbitrators are people with very high standards of integrity, but we wanted to make sure in those rare instances where there are real issues, like an arbitrator simply not disappearing, for example, or really blatant cases of, say, overcharging. So we wanted to make sure that in those really rare exceptional circumstances as an institution, we are able to act. And maybe I'll just cover the third point first, because again, HKIAC power to review tribunal fees, even though we've introduced this into our 2024 rules, I don't expect us to be reviewing tribunal fees as a matter of routine. It's only in some rare instances where, as I mentioned, like blatant overcharging, we want to be able to have an ability to review and make adjustments. The one in the middle, that's in relation to conflict of interest. Actually, at a session yesterday at LIDW, I've heard a practitioner saying that he's seen a situation where a party would deliberately change counsel to create a conflict situation to engineer delay to proceeding. So we've added a provision in our 2024 rules to say that after consulting parties, a tribunal could take measures, including to exclude the proposed new party representatives to avoid this sort of conflict situation. The third area on our key changes is to respond to developments in arbitration and in the world. The first one is diversity. And on HKIAC's practice, it actually hasn't changed anything, because even in the past, when we appoint arbitrators, we already take into account diversity amounts, other factors. But we want to make that absolutely clear. So we've now put it in our rules to say that we HKIAC shall take into account diversity. So that merely codifies an existing practice. We've also included a subclause to say that parties and co-arbitrators are encouraged to take diversity into account when designating arbitrators. And I think this is pretty interesting because this provision received a lot of comments during the consultation process. On two extremes, some people think that we're not going far enough in saying simply encouraging parties. You need to be a bit more forceful in your wording. Some people think that you are going way too far in putting this into your rules. But this is where we landed on, like encouraging parties, which we think strike the right balance, because I think the people who are concerned about putting it in was that whether it provides a new avenue for parties to, say, challenge arbitrator appointments. So we try to balance the different considerations in putting this in. Another comment that we got was, what exactly does diversity mean? And simply by saying diversity, do parties and co-arbitrators know what they should be thinking about? And in the end, we kept it general just because diversity is such a broad concept. So we want to keep it simple in our rules, but we'll release practice notes to further elaborate on different types of diversity, not just gender, but cultural, ethnic diversity, age diversity, etc. Sorry. Then the next one on greener arbitration. Again, I think this is not controversial, like greener arbitration, information security, not controversial changes. So in terms of adopting suitable procedures for the arbitration, we've now added environmental impact as one of the factors that tribunals should consider when adopting procedures. So say whether you have everyone fly in for an in-person hearing, or whether it's sufficient to have just a virtual hearing. Hopefully this gives tribunal and parties a reminder to think about the environment when devising those procedures. And likewise, we've added adverse environmental impact arising from parties' conduct as one of the factors that a tribunal may take into account in allocating costs. And hopefully, I hope this also achieves some kind of deterrent effect, so that parties would think twice before doing something very wasteful and costly for an arbitration. And information security, as I've mentioned, not a controversial change. I think with the advancement of technology, tribunals and parties should think a lot more carefully about the measures that need to be put in place to protect information security. So that was an overview of the key changes. Now I want to spend a few minutes to tell you a bit about the mainland China, Hong Kong interim measures arrangement. And I think when we talk about interim measure sought from mainland Chinese courts, some people may think it's strange for me to focus on, because a lot of jurisdictions, a lot of courts in other jurisdictions already have the power to issue interim measures in support of foreign seated arbitration. So for a lot of courts, that's not something special. That's what courts do from time to time. But the situation in mainland China is not the same. So typically, mainland Chinese courts do not issue any form of interim measures in support of foreign seated arbitrations. This is why this arrangement, when it came into force in 2019, was a game changer, because Hong Kong became the only jurisdiction outside of mainland China, which would allow a party to seek interim measures directly from a mainland Chinese court in support of their arbitration seated outside of mainland China. So in order for a party to do that, it would need to be a Hong Kong seated arbitration and administered by a list of institutions. So that includes HKIAC. And if so, the party can apply directly to mainland Chinese courts to get orders on preservation of assets, preservation of evidence, or preservation of conduct, which is what people here would think of about injunction and specific performance. But in practice, what has really been effective is preservation of assets. So evidence, conduct still really rare, if at all. This has been used very effectively. And I think the other reason why it's been a game changer is also, say, if you're in a foreign seated arbitration and you, say, successfully obtain interim measures from the tribunal, that still can't be enforced in mainland China. So if a party really wants to, say, freeze assets in mainland China for the duration of the arbitration, then this is their way of doing so. So since 2019 October, HKIAC has already handled 123 applications for these interim measure applications. And as you'll see from the map, it may not be completed. There may be some more, but a lot of the mainland Chinese courts have issued orders or review these types of applications, and the total amount of assets which have been preserved go up to $2.3 billion US, so used very effectively. Actually, not just by foreign applicants, so around 80% are foreign applicants, but 20% are mainland Chinese applicants. 60% of the respondents are mainland Chinese parties, unsurprisingly, but actually 40% are foreign respondents with assets in mainland China. So this is just a quick overview of how the arrangement operates. But yeah, it's something that's been very practical, very effective, and a unique advantage to Hong Kong seated HKIAC arbitration. So I think that's my slide. I hope I've kept to time. So I'll hand this to Nick or Maria.
Thank you, John. Perfectly on time. So, Nick, please.
Great, thank you. Well, look, thank you very much to Maria and for the School of Arbitration for organising this session. It's always a pleasure to come back. I know Julian Liu is one of your teachers. He was also one of my teachers. I worked for several years under Julian when he was a partner at Herbst with Freehills. Congratulations, Joanne, on your relatively recent appointment. And thank you for your presentation. It's clear the HKIAC is in rude health and is doing very well. I think just a few comments from me first about the HKIAC in Hong Kong as a jurisdiction. It's a tremendously important jurisdiction. Hong Kong is one of the 5 top choices for institutional arbitration as found by the White and Case Queen Mary survey last in 2018 for international arbitration institutions, to distinguish them from, perhaps the domestic institutions like CTAC or the AAA. But it's a top 5 choice because it's a significant jurisdiction. It's got a long history of arbitration. And so Hong Kong matters not just for Asia, but for the world. I was pleased to see the stats this year for Hong Kong arbitration. As Joanne says, it's a good and steady caseload, and it's been going up. I actually found some stats going back to 2016, and it's clear that there's been an increase from between 262 and 344 cases per year across that time period. And then we've got 281 this year, which is an impressive caseload. Yes, as Joanne says, it's less than last year, but it's more than the year before. And actually that sort of spike up and down has been mirrored by a few institutions in recent times. To put that in perspective for those in the room, the LCIA released its stats for 2023. It's got 327 cases this year, a little up from last year. So, HKIAC is in that sort of range, and is an important institution. But stats don't tell the full story, nor are they everything. I think another important point about Hong Kong, and it's also true about London, is Hong Kong is a deep arbitration market with a lot of ad hoc arbitration, as befits a jurisdiction that's always been significant for trade and for maritime work. So I've always viewed HKIAC, as I view the LCIA, as a sort of a signifier of the health of that arbitration market. It's not everything, but it's a good thing to look at. And I think, again, it's important that we see that HKIAC is showing good health there. Very important point in practice that Joanne made about the use of HKIAC in Hong Kong in arbitrations in relation to mainland China. And you saw the stats of the non-Hong Kong parties involved in HKIAC arbitration, and number 1 was mainland China. And then we saw also USA on that list, Russia, Korea, Japan, UK, major economies, major players in global trade, plus a number of, you also saw some offshore jurisdictions there, BVI, Macau, Singapore, Cayman, which are no doubt being used in structures very often in relation to those jurisdictions. So it's important, again, that people are using it. And Hong Kong remains, for a practitioner, such an important intermediary for mainland China. And interesting to hear that 40% of arbitrations have a mainland Chinese counterparty. That doesn't surprise me, but I think it's a really important stat. And again, that signifies and is important about Hong Kong's relevance. Hong Kong matters for global trade. Hong Kong rule of law matters, and arbitration in Hong Kong matters. So, I mean, great and well done, HKIAC, for your continued involvement in that. Just one other point on John's last comment about this China-Hong Kong court assistance. Again, really, really important. And again, it'll add to the use of Hong Kong by parties in arbitrations or in contracts, of course. This is going to the contract when you're contracting with a party in relation to mainland China. John, you said 123 applications in a little under 5 years since that regime was introduced. So that's 25 a year. Once every fortnight, a party is making use of this mechanism. So clearly it's valuable. Clearly parties are using it. On the rules, a great set of revisions, I think. I was having a read of them, and Joanne put them into themes. I had 3 different themes, actually. I'll give you mine. I thought HKIAC, as with many institutions, all institutions revise their rules every couple of years. And I think they're trying to do 3 things at the moment. One is to improve, if they can, the robustness of the process, to make sure the powers are there for the tribunal and the powers are there for institution to make sure that arbitration works as well as it should do. And that means giving both powers and duties to both those. Secondly is updating arbitration. We've frankly undergone a bit of a generational shift, I think, in the last 10 and possibly even the last 5 years about the way business is conducted and the way arbitration is conducted. And I think I'll come back to that, but I think there are a few updates there that definitely go into that. And then lastly, a heading on itself, diversity. This is a really important topic. And as Joanne said, it's not an easy one to address. And I'll come on to the way they've done it because I like it. But if we don't improve diversity of arbitration, then we won't keep it relevant. We've got to grow the pool of arbitrators in particular in order to encourage parties to see that the arbitrators will reflect the world in which they operate. And we've got to do that to keep the legitimacy of the process. Just a few thoughts, I think. I'll a couple of highlights on within those headings. Firstly, on the robustness of the process. I liked, as Joanne said, that 13.6 of the new rules. Get yourself a copy if you haven't. I know Julian Lau will always tell you, read the rules, read the rules. It's true, you've got to. 13.6, powers, as Joanne said, to determine preliminary issues, to bifurcate, to have sequential stages, decide at what stage any issue is decided. And absolutely, we've talked for years about these powers being inherent and implicit in rules. And of course, tribunals have the power to decide a preliminary issue if they want to. But tribunals weren't doing that. And when you are faced with one party saying, please do it, and the other party saying, no, you shouldn't do it, and you can't do it, relying on that implicit power was a little bit edgy for some tribunals. So absolutely writing that expressly in the rules and saying, look, you do have this power, you can point to it. And that will help a party define that power. And let's be honest, parties, when they get into arbitrations, comb through the rules, and for both their interests, they'll try and find something they can use and that works for them. So it helps parties to come across that and think, well, should I use that in this arbitration? And it helps tribunals to know that that power is there, and that if a party asks them to exercise it, they shouldn't be hesitant in doing so. I like the early determination procedure. This idea of manifestly outside the jurisdiction, manifestly without merit. I've been asked myself to apply that in institutional arbitrations. Another really important one in practice was the point Joanne mentioned about the ability of the tribunal to prevent a change in counsel before it happens. And the previous rule said, well, once you change counsel, you notify the tribunal. And absolutely, as Joanne said, the risk and the danger there in what we often term guerrilla conduct in arbitration is that a party that was not doing so well maybe in the process, or just for its own reasons wanted to disrupt and delay the process, would introduce at the last minute, at a late moment, a new counsel. Here you go, here's new counsel. Oh, by the way, it's a barrister from the same chambers as one of the arbitrators. Oh, by the way, you know, it's somebody with some other connection, putting the tribunal under pressure, because if you can't control that introduction of counsel, then what's the option? The option often would be a tribunal having to say, well, should I, remove myself from the process? Do I have to resign? In which case you have to reconstitute a tribunal. There's delay, there's inefficiency. Now, in any given dispute, that may be in the interest of one party at a particular time, but it's not in the interest of the arbitration as a whole. And when you're running an arbitration as a tribunal, and when you're trying to structure it as an institution, the interest you're trying to protect is of the parties when they choose institutional arbitration, when they decide that HKIAC arbitrations for them and they write into their contract. That's the interest. You want to fulfill their expectations in a robust, efficient process at that stage, knowing that when the time comes and the dispute arises, depending on whether they're the claimant or the respondent, they might have very different interests in how the arbitration runs. So it's important as an institution, as a tribunal, to remember that's the expectation that you're trying to uphold. I liked the new power to control the tribunal in the HKIAC, as Joanne said. Hopefully it'll be exceptional circumstances when you have to think about removing a tribunal member, or hopefully about reducing the fees due to any tribunal member. But it's important they're there, because sometimes, and these are rare instances, when arbitration goes wrong, it's not always the parties with their guerrilla tactics. It can be arbitrators who, for whatever reason, fail to fulfill their duty. And it's important that the institution has that power to control its process, and frankly gives the parties a route to ask those questions. Because if that's, just think about it, if the institution's not there and doesn't have that power, and your tribunal has just gone to ground, you had your hearing 6, 7, 8 months, 9 months ago, and you don't know where the award is, you don't know what's going to happen. You see the arbitrator on LinkedIn flying around the world, or maybe you don't. Maybe they've disappeared. You hear rumors they're in bad health, or they've got a new business venture. how do you deal with that? Well, what you do with an institution like HKIAC involved is you phone them up and you say, can you please find out where the arbitrator is? And what this does is give the HKIAC power, a bit of leverage to twist the arm of any given arbitrator and say, look, sunshine, are you going to produce an award? Do you want us to reduce your fees? Or frankly, if you're not, and you can't give us a good reason, then, you know, it's draconian, but we might have to remove you from the tribunal. So look, it's a rare power, but it's an important one for the robustness of the process. Updating arbitration, just a couple of things. I mean, as I say, the process has changed. When I started out with Julian Lau, you know, hearings were in-person hearings. And then if you occasionally had to argue over a Redfern schedule, you'd huddle over a speakerphone in the middle of a desk in Julian's office. The world has moved on for you know, very, very good reasons. I think just apart from the practical aspects of arbitration, I like the two updates here around environment and IT security. I'll call the green and the grey. The green is important. Again, environmental impact, but I think it's more interesting than perhaps Joanne let on when she was describing it. So there's a 30.1. There's the duty on the tribunal when fixing suitable procedures for the conduct of the arbitration to take account of environmental impact. Okay, that's an interesting one. There's a duty to think about it. But as Joanne mentioned, when determining costs, the tribunal can also take that into account. The tribunal should take into account circumstances which may include any adverse environmental impact arising out of the party's conduct in the arbitration. Now, I find that quite interesting, both as a counsel and as an arbitrator who might have this argued. What does that mean in practice? If a party wins, but they turned up at the hearing with hard copy bundles, is the other side going to say you should reduce their fees? Likewise, if one party flies into the hearing, comes with 10 people, and the other side comes with 3, should that be taken into account? If a party wins, but there's an aspect of its conduct that is said to be adverse to the environment, unnecessarily so, how does that get argued before the tribunal? And whose interest is the tribunal defending in reducing a successful party's costs because of the environmental impact? I mean, the arbitration is an inter partes procedure, and yet here we are introducing a dynamic that suggests we're protecting, an interest, if you like, outside the arbitration, frankly, an interest everywhere, isn't it? Environmental impact. So I think it's conceptually quite an interesting one. But in practice, of course, parties will want to maximize their cost position. And they'll want to look for arguments they can make on costs against the other side. And they'll be alert and astute to not giving the other side arguments about whether we produce bundles or whether we flew too often. And of course, in reality, that will impact behavior. So, what we will, of course, find is that it will impact, and parties will think twice before taking steps that could be used against them. So they maximize their cost position, and in doing so, maybe help the environment and the legitimacy of the arbitration process. The grey is information security, the most important dull topic in international arbitration. It is such an important topic in practice. There is so much data in international arbitration, and a lot of that is very sensitive and important data. Commercial secrets, personal data of individuals, contracts, licenses, JV arrangements, negotiations, capitulations, proposals, all sitting within that big PDF that one party attaches to their submission or within the data dump that is given in response to document requests. Again, it's more interesting in the rules than it looks at first. Yes, the tribunal must adopt procedures, mindful information security, that's in 13.1. But the really interesting provision is 45A. This is the new provision. Parties may agree on measures regarding information shared, stored, or processed in the arbitration. Sensible enough, all fine. The tribunal, after consultation, may give directions regarding protection, which is important because, again, some of this data and some of this sensitivity may relate to third parties outside the arbitration. So who's going to just make sure those interests are looked after? But really, really interesting, again, on costs. Well, no, actually on cost and remedy. 45A3, the tribunal after consultation may make a decision, order, or award in respect of any breach of the information security measures agreed by the parties or directed by the arbitral tribunal. So you've given teeth to this You've said we can agree or the tribunal can direct certain measures. And then you said the tribunal has a power to give a decision, order, or award in relation to breaches of those directions. Now, again, conceptually, and it's a topic for another day. You can pick this up in another seminar. What does that mean in practice? What's an award look like? And what damages am I giving and to whom for that sort of breach? I think it'll take some careful thinking, and I will be interested to see how parties argue it. So watch that space, I think. And then lastly, and briefly, but not because it's not important, diversity. Joanne's captured this. It's such a hot topic. It's such an important topic. I think it's difficult to put into words, and I like the way HKIAC has done it. So what it says is under the new rule 9A on diversity, for a start, it's there. When you skim down the rules, you'll see it's there. So everyone knows a point they need to have in mind, and the tribunal and the institution will have in mind. Parties are encouraged to take into account considerations of diversity when designating arbitrators, but HKIAC shall. So it's not encouraged, it shall take considerations into account in making appointments, along with other relevant considerations. And I think that's frankly well done. You can only encourage parties. You can't dictate to them. I think Joanne's right. I'd agree with anyone in the consultation who said you can't tell parties who they appoint. But I think the encouragement is important, and I think it does work. It's pretty rare now in this market to see a homogeneous list of proposed arbitrators. And when occasionally one comes across your desk, you spot it and go, hang on a minute, this all looks like, all the same species, as it were, of arbitrator. So that's pretty rare. That's happened. That change has happened because in this market, a number of agitators and a lot of supporters have said, we can't just go on with being lazy. The pool is changing, but we also need to change our attitude as well. So the encouragement does work. Of course, it's then harder to force your clients to move away from those safer choices they've known about for many years. But the first step is to make everybody think outside the box a little bit. And again, as the generation changes and as we evolve arbitration practice, this will become easier and more natural to do. So I think it is important. Sometimes we think it's easy to say but hard to do. I don't think it is hard to do, actually. But I think it's hard to legislate. So putting it into the rules, I think, is difficult. And I like the elegant way the HKIAC has done that. So I congratulate you on that. And those are my thoughts. Thank you.
Thank you very much, Nick.